This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today we're going to speak about why Wisconsin and its Supreme Court found that killing an insured's child was actually a potential accident even after the insured was convicted for second-degree reckless homicide. When there is a severe injury, like the criminal death of a child, litigation almost invariably results in an attempt to collect from an insurer, since the convict will have little or no assets to pay for the loss. In Lindsey Dostal versus State Farm Fire and Casualty, a Supreme Court of Wisconsin decision dated January 26, 2023, the Wisconsin Supreme Court was asked to allow the mother of the child, who was murdered or killed as a result of the negligence of his parent, to seek insurance proceeds from the insurer of the father of the child, claiming the injury was accidental, regardless of the fact that the father was convicted of a serious crime, second-degree reckless homicide. Lindsey Dostal, the mother, sought review of the decision of the Court of Appeals affirming the Circuit Court's grant of summary judgment and declaratory judgment in favor of State Farm. The Court of Appeals determined that Curtis Strand's conduct did not constitute an, quote, occurrence, close quote, covered by the State Farm policy at issue, because his conviction for second-degree reckless homicide established that the death was not the result of an accident. State Farm had asserted that the issue preclusion rules bar relitigation of the issue of whether Haeven's death was the result of an accident. It argued that Strand's criminal conviction was dispositive on the issue of available insurance coverage under Strand's policy, and that there was no coverage for Dostal's claims. State Farm further contended that the policy's resident relative and intentional acts exclusion precluded coverage. Now, Dostal gave birth to Haeven on April 3, 2017, and Strand was subsequently adjudicated the father because the mother and father had an off-and-on relationship. On July 11, 2017, Haeven passed away as a result of a head trauma that occurred while she was in Strand's care. After a jury trial at which Dostal was a witness, the jury convicted Strand of second-degree reckless homicide and resisting or obstructing an officer. Dostal sued Strand for negligence and wrongful death rather than for the intentional killing of her child, and Strand tendered the matter to State Farm, his homeowner's insurer, seeking defense and indemnification. State Farm argued that its policy did not provide coverage for Dostal's claims, and it thus had no duty to defend or indemnify Strand. State Farm asserted there was no occurrence, defined as an accident, triggering coverage. The district court agreed with State Farm and granted its motion for summary and declaratory judgment, and the Court of Appeals affirmed. The insurance policy in the case set forth that coverage is provided for, quote, an occurrence, close quote, and an occurrence in term was defined under the policy as an accident which results in, and as relevant in the case, bodily injury. The offense of second-degree reckless homicide requires that the actor, Mr. Strand, creates an unreasonable and substantial risk of death or great bodily harm to another human being, and the actor is aware of the risk. And he was, because he dropped the kid on her head and then put her to bed, only to find her dead the next morning. State Farm also concluded that the resident relative exclusion in its policy applied because, in State Farm's view, Haeven was a resident of Strand's household as a matter of law. It pointed to facts in the record indicating that the paternity court had ordered Strand frequent physical placement of Haeven, that Strand physically cared for Haeven, and that Strand intended the duration of his relationship with Haeven to be substantial such that he would consider her when contracting about insurance. And at the time of the death, Haeven was in his house being cared for by Strand alone, in accordance with the court orders giving him physical placement. However, contrary to State Farm's argument, in Dostal's deposition, she testified that Haeven's residency with Strand was disputed. According to Dostal's deposition testimony, Strand only cared for Haeven without Dostal present 4 times, a count which includes 2 overnight stays. Dostal further testified there was no formal schedule for placement and that Strand was usually too busy or didn't have time for the baby or didn't want her over there. Given this testimony, the Supreme Court concluded that it could not conclude as a matter of law that Haeven was a resident relative of Strand because there was a dispute as to the facts. Of course, the baby was very young and didn't have a lot of time to be with her father before she passed away. The parties' submissions demonstrated to the Supreme Court that there were genuine issues of material fact as to the question of whether Haeven was a resident relative of Strand. Accordingly, it found summary judgment was inappropriate. It then considered the intentional act exclusion. If the conduct is intentional, and if the contact is substantially certain to cause injury, the Supreme Court could infer intent to injure only if the degree of certainty that the conduct will cause injury is sufficiently great to justify inferring intent to injure as a matter of law. However, the Supreme Court found it could not infer intent to injure as a matter of law merely because of the insured's intentional act violated the criminal law. Conviction of a crime gives rise to an inference that an insured intended injury as a matter of law in 2 circumstances, but only 1, if intent to injure is an element of the crime, or 2, if the crime in question involves the insured committing an intentional act that carries with it substantial risk of injury or death. Dropping a kid on her head might have been something that could be considered intentional or carry a substantial risk of injury or death. However, since intent was not an element of the reckless crime, if the intentional act exclusion was to apply, the crime must involve the insured committing an intentional act that carries a substantial risk of injury or death. A determination that Strand's conduct was reckless does not, at least to the Wisconsin Supreme Court, preclude a finding that his conduct was an accident for purposes of insurance coverage. In sum, the Supreme Court concluded that issue preclusion does not bar Dostal from seeking insurance coverage for her claims against Strand. The issue of whether Strand's conduct constituted an accident was not actually litigated in the prior criminal proceeding, and there are genuine issues of material fact regarding the application of the resident relative and intentional acts exclusions such that summary judgment is inappropriate. Chief Justice Annette Kingsland Ziegler and 2 other justices dissented because they concluded 12 jurors at Strand's criminal trial unanimously decided beyond a reasonable doubt that Haeven's death was not an accident, and this precluded relitigating the issue of Strand's coverage. Strand's conviction for his act of reckless homicide, killing his own child, Haeven, precludes Strand from claiming that Haeven's death was an accident. If the defendant did not act with an awareness required for this crime, he was not guilty of the crime. Since he was convicted by the unanimous vote of 12 jurors, he acted with the awareness required for the crime. He will serve his time in jail for the crime. Strand's criminal trial is not binding any non-parties to that trial. The Chief Justice and 2 of her colleagues concluded that the criminal trial only binds Strand by precluding him from claiming that his criminally reckless act was a covered accident, absolving him of liability to Dostal. In my opinion, since this is a decision reversing the granting of a motion for summary judgment, it gives Dostal the right to attempt to bring sufficient evidence to a civil jury that convinces them that the death of Haeven was an accident, and that she was not really in the house with her father as a resident relative. It will be difficult, and State Farm will present its evidence to prove that they are right. But since she only needs to convince 9 of 12 jurors that the preponderance of the evidence, not beyond a reasonable doubt, contradicts the conviction of the crime found by a unanimous vote of a jury, convicting Strand for the death of his child, the jury may feel sorry for the mother and punish Strand's insurer to help the mother. To me, the dissent is much more convincing than the decision of the majority, but the decision of the majority is the law now in Wisconsin. And you can kill your child recklessly and still have insurance coverage for any suit brought by the child's mother for the child's death. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And if you subscribe to the blog posting, you will receive notice of all blog postings, more than 4,400 so far, usually 5 a week, sometimes more. And you can also subscribe to the videos at rumble.com and at youtube.com, where you can be advised of the videos as they are published 5 a week or more. If you found this video or the blog posting to be useful to you, please tell your friends and colleagues so that they can also subscribe to the blog and the videos. And if you found it useful, you might also wish to join my locals community and my Substack publications, where for a small fee you will be given additional, more dedicated information about insurance claims and insurance claims handling and the law of insurance. Thank you for your attention.